change our total OBs to 35. And does that change the level?
Good, Your Honor. Changes it to a level 4. And so a C4 cell is going to be 523. So,
All right. Any other additions, corrections, or deletions from the people?
no, nothing from the people, and I know nothing else from the people.
So you've read the statement into the record, then nothing else from victims?
That's correct, Your Honor.
And then anything on behalf of then the people?
Your Honor, the recommendation on the 0 to 17 guideline range is 12 months on count 1 and 2, and 2 years on count 3 preceding the count 2 sentence. The people did initially support that, but with the change in the sentencing guideline range, obviously this does open up, Your Honor, to more opportunity for incarceration if you so choose, and we would leave that at discretion. But otherwise, we ask that you at least follow the recommendation as intended by Congress.
All right. So, Mr. Hensley, I'm going to give you the opportunity before I ask you to address the court for sentencing. Do you have any additions, corrections, or deletions as it relates to the pre-sentence report?
Yeah.
Do you have any additions, corrections, or deletions?
All those accusations are false, and none of them have been proven. Okay. Not one. And he talked with this story.
As it relates to this report, do you have any additions, corrections, or deletions? Excuse me?
No, I don't have the report.
All right. So, as it relates to sentencing, is there anything that you want to state to the court before a sentence is imposed?
You know, I have my medical information. You know, I have stage 3 cancer. You know, I have head trauma. You know, I have neck and back injury and something with a dry foot.
Anything else then, Mr. All right. So Mr. Hensley has provided, it is accurate, information regarding different medical issues that he has, that he is suffering and is suffering today, as a matter of fact. However, as the court sat through this trial, it's clear to the court that what Mr. Hensley was engaged in is troubling. The testimony of these victims where they were traveling on westbound I-96, minding their own business, when Mr. Hensley's vehicle comes up behind them at a high rate of speed, the victim described with great clarity how close Mr. Hensley and his vehicle were to them, to the point they were extremely uncomfortable. Did not, hold on, Mr. Hensley, let the court finish, okay? To the point that they thought they were going to be struck. The victim, I recall, describing being unable to even see the front of Mr. Hensley's vehicle. That's how close it was, meaning the grill, headlights, I recall the testimony, and that they immediately got over. Victim then went on to describe that Mr. Hensley pulled up next to them and pointed a handgun in this manner, of course, pointing over to the right and directly at these individuals. The victim described how he reached back, started to shield his family, and that they were getting down as best they could. Now, all of that, I think, is certainly actions that would cause the victims here to feel their life was in danger if somebody points a gun at them. The fact that somebody is tailgating back closely behind them on the highway at speeds of 70, 75, 80 certainly puts people in danger, could cause people to be incredibly uncomfortable about what's going to happen next. But it's a long way, Mr. Hensley, the court saying, having sat through the trial, you create the situation by driving in a manner that makes these folks uncomfortable, by coming up on them at a high rate of speed and following them that closely.
Objection, man.
Mr. Hensley.
I drive a BMW. Anybody with an autopilot vehicle, you know for a fact he won't do that.
Right.
That's a fact.
So Mr. Hensley.
Not what he giving you on out of his mouth. A fact. An automobile will not get up on nobody. Automatically jam brakes. I told you BMW does that.
The trial is over. You had an opportunity to cross-examine those witnesses.
I did that, and you deleted everything I said.
Yeah, court
and you heard everything that they said was a lie.
So now,
and you know it was a lie.
Let the court finish. All right. So the testimony was as the court has described, and there is no doubt that all of those actions Mr. Hensley is responsible for. That's the ironic part of it. He creates the situation that causes discomfort for these drivers, and then he's the individual that introduces a gun to the situation. Court heard 404B evidence that was remarkably similar, where Mr. Hensley is right on the bumper of a young lady Grand Rapids, Kent County area. And then when she is very uncomfortable and pulls over and stops, Mr. Hensley again introduces a gun, pointing it at that individual. Now, I mention this because I'm not using that as it relates to a sentencing issue. I'm using that and that it's clear Mr. Hensley drives in a manner that endangers other people, that causes them to report his activity to other people. And then when they attempt to evade, if you will, what Mr. Hensley has caused, then he introduces a gun to the situation. Now, Mr. Hensley, I don't have to tell you that it's fairly obvious that in today's world, right, today's world of shall issue CPLs, that even if you believe that somehow you're justified in displaying a weapon, and for the record, there's nothing in this trial, nothing this court heard with the 404B evidence or the incident at hand here that we're sentencing you on that would suggest that in any way, shape, or form that you were not responsible, that you had any legal justification to introduce a weapon to it. But even assuming in your own mind that you were, what happens with that in today's world is they would have a very easy avenue to articulate, I felt in fear for my life or great bodily harm, and assuming they were lawfully carrying a gun, could take action, shoot you, in other words. And I can remember just in Little Ionia County, an incident that occurred just a few blocks from here, in which an individual was tailgating a lawful CPL holder going right down Steel Street over here. And so that individual, much like here, got over, pulled into the car wash to get away from this guy. And the guy behind him pulls right in behind him, much like in the 404B evidence I heard with you. And so what happens is the CPL holder, what is this guy doing? He's crazy. He pulls his gun. Now, you can argue whether he could articulate at that time whether he felt his life was in danger of death or great bodily harm. But regardless, so what happens is the tailgater, he then also was a valid CPL holder, and he pulls his gun. And guess what they did? They shot each other, and they both died. The ironic thing is maybe it's the one time the government program worked 100%, because to get a valid CPL, you have to take this course, do all those things, and part of that is shooting your gun 15 times or something. I can't remember.
I worked on my own call. I knew about a CPL.
No, well, my point is, so they both hit their mark, and they're dead. And it's started from something just like this. And so my point in demonstrating the story to you, retelling the story, is when you engage in this kind of behavior, it puts your own life at risk. Put your own life at risk. And that you're lucky that hasn't occurred to you, but you certainly have frightened the heck out of people with what I heard in this trial. You certainly were in the wrong, and you're not a valid CPL holder. That's the other problem.
Because I don't need it.
All right, well, I recognize you think that you have some fundamental rights that I'm not aware of found either in state or federal constitution, and you certainly can take those up on review, right?
I'm already in Western District Code already.
So that's fine.
Okay.
You can appeal anything that you'd like,
yeah.
any reason you think you have a valid appeal, but they're simply not found in state or federal constitution. And so here we are today. So that's how we end up with a carrying a concealed weapon, felonious assault, felony firearm. And what the court likes to do, Mr. Hensley, as I'm reviewing this, I will say this, I'm weighing positively in a positive manner here. You stand before the court at age 50, you don't have any prior criminal history.
Exactly.
Which is somewhat remarkable when I heard about the 404B evidence. So
Exactly.
I don't know how that didn't result in some sort of crime, but it didn't. And I'm recognizing that, and I'm going to recognize that in the sentence I'm going to impose here in a minute. We do have the sentencing guideline now, which is 5 to 23 months. Court likes to think about the middle. The middle of 5 to 23 is going to be 14. And I also want to recognize that you don't have any prior criminal history, and that I will also recognize until lately that you've been cooperative with the court. You showed up to court, that you, as far as I can tell, did your very best to represent yourself, and were adamant about doing so and took this matter seriously. All of those things, I think, are things the court can weigh that are positive to you. The negative, though, sir, is the outcome of this is your actions and one causing this and then making it worse with introducing the gun and pointing it at this family on the date in question.
Can you prove that?
They did prove that.
No, they
On the
did not.
reasonable doubt
No, they
at
did
trial.
not.
I recognize you disagree with that.
Because you had
asked the court to
you
decide
had
it,
photos,
and
you
the
had
court
video,
decided it.
you had somebody's mouth.
Those are all
Yes.
evidentiary issues that you, again, can explore on appellate review, sir. You're welcome to do that.
Yes.
All right. So as it relates to the carrying a concealed weapon, all right, so carrying the concealed weapon is count or charge number 1. Court's going to impose a sentence of 12 months to 5 years. That's under the minimum guideline range of, or the middle, I should say, of what the court was looking at 14 months. So it'll be 1 year to 5 years with the Michigan Department of Corrections, and you do have credit now for 14 days that you have previously served. As it relates to the felonious assault, now this would be charge number 2. The court's going to impose a sentence of 1 year with the Michigan Department of Corrections to the statutory max of 4 years. You will receive credit for 14 days that you have previously served. And then as it relates to count 3, this is the felony firearm. The court is required, Mr. Hensley, to impose a sentence of 2 years with the Michigan Department of Corrections. And then counts 1 and 2 that I mentioned earlier will be served concurrently with each other, but this count 3 by statute is required to be served consecutive with and preceding these other 2 counts. So 2 years with the Michigan Department of Corrections. As it relates to the monetary obligations, Mr. Hensley, the court is required by statute to impose $130 as a crime victim rights assessment. Court's going to impose court costs in the amount of $1,500. There'll be a $60 DNA testing fee, and then required by statute are these state costs in the amount of $68 on count 1, $68 on 2, and $68 on 3. All right, so Mr. Hensley, you do have a right, and this is something you're interested in. You've expressed that interest to seek appellate review of the sentence the court has imposed. If you'd like to do that, you have 21 days from today's date to make that request. You have the appellate paperwork there.
Right in front of him, along with the pen.
All right.
He's already in the district court. You want the case number?
So hold on. So you have 21 days from today's date to make that request. All right. If you want to ask for a court-appointed attorney as it relates to this appellate review, you have a broader window of 42 days to make that request. Okay. Because you were convicted at trial, you have an automatic right to seek this review, meaning that if you ask for that review, then the appellate court will have to take a look at it. All right. So if you can, then there's a pen there. I need you to sign. There's 2 copies of that. One for you to keep, the other one for you to initial and date that you've received it. So if you could do that for me, sir, it's right there on the podium.
You can take that with you. I'm not signing anything.
All right. So for the record, Mr. Hensley Bay is indicating you don't want to sign that, sir?
I'm not signing anything.
All right. So for the record, then, though, I am going to send back with the deputy his copy of the appellate review form. I'm going to place the unsigned appellate review form here, Mr. Hensley, only because we've dealt with this case for so long. If you want to explore these, though, this form is important to you. Okay. I recognize that you are refusing to sign it or acknowledge it for the record, but this is something that you want to file